Welcome to this deep dive. We're here to help you get to grips with the fundamental building blocks of trust law.
Yes, and let's be honest, the terminology can seem, well, pretty dense at first, a bit overwhelming.
Exactly. But that's what we're aiming to cut through today. We'll be drawing on the excellent materials made available by the University of London for educational purposes.
And just a reminder for everyone listening, this discussion is purely for educational purposes. It really shouldn't be taken as legal advice.
Absolutely. So, our mission today, to really unpack the different kinds of trusts.
We'll be looking at express trusts, fixed discretionary bare trusts, also those that arise by operation of law, constructive and resulting trusts.
And testamentary, inter vivos, purpose trusts to both charitable and private ones.
The goal is to give you a solid framework, help you study effectively.
Sure.
We'll be focusing on the core ideas and, crucially, those key case names you need for exams.
Right, and we'll be referencing Penner throughout chapters 2, 3, 10, and 17 are particularly relevant here.
Understanding this language isn't just academic box ticking. It's vital for understanding how trusts actually work.
Okay, let's dive in. Express trusts. What makes a trust express?
Well, an express trust is one that's deliberately created. The settler, that's the person who owns the property, initially makes a conscious decision to set up a trust.
So they either declare they're holding the property on trust themselves.
Exactly, becoming a trustee themselves. Or they transfer the property to other people, the trustees, to hold for the beneficiaries, or maybe a charitable purpose.
And they have quite a lot of freedom in how they set that up, right? This idea of freedom of trust.
They do. They can divide up the entitlements, the benefits,
Yeah.
in various ways. But the crucial thing is the intention.
Ah, yes, the intention to actually create a trust.
Precisely. There has to be a clear intention to impose a legal obligation on the trustee. Just expressing a hope or a wish, what we call precatory words, usually isn't enough. It needs to be more certain than that.
Okay, so assuming there's clear intention, how can these express trusts be structured? Let's start with fixed versus discretionary. What's the main difference there?
Right. The key difference is about the trustee's job when it comes to handing out the property. In a fixed trust, the trust document itself spells out exactly who gets what and when.
So the beneficiaries and their shares are all laid out from the start.
Yes. Determined right at the beginning. The trustees have zero choice in the matter. Their job is just to follow those instructions. The beneficiaries have a definite right to their specific share.
Okay, like a fixed script. No ad-libbing allowed for the trustees. How does that compare to a discretionary trust then?
Well, with a discretionary trust, the trustees are given a choice, a power of choice over how the property is distributed.
But only within a certain group of people.
Exactly, within a defined class of beneficiaries. But, and this is really important, they still have an obligation to distribute it. They don't have to give it equally. They can decide who gets what and how much based on their discretion.
So it allows for more flexibility, maybe adapting to changing needs.
That's the main advantage, yes. Like instead of saying £10 each child, you might say, to my trustees to distribute the fund amongst my children as my trustees think best. It's a wait-and-see approach.
Got it. Now, you said fixed refers to the share, not always a specific amount of money right away.
That's a really key point,
Right.
yes. For example, a trust could say, pay the income from these shares to my spouse for their life and then give the shares to my child.
Okay.
Now, the amount of income might fluctuate year to year depending on dividends, and we don't know how long the spouse will live. So the total amount isn't fixed up front.
But the trustee has to pay whatever income there is to the spouse.
Exactly. They have no discretion about whether to pay the income or who gets it. The entitlement to the income is fixed, even if the pound amount varies.
Right. That distinction is clear. What about things like contingent interests or defeasible interests? Do they still count as fixed?
Yes, they do, because the conditions are set out in the trust instrument, not left to the trustee's discretion.
So a contingent interest is like you only get the money if something happens.
Correct. For instance, you get the trust fund when you graduate university. The graduation is the contingency. Until then, your interest is contingent.
And defeasible.
That's where an interest can be cut short if something happens. Like you get the income unless you win the lottery. If you win, your interest is defeated.
But in both cases, the rules are set, the trustee just applies them.
Precisely. They aren't deciding whether the condition applies, just whether it has happened. So still classified under fixed trusts.
Okay. And can you mix and match? Have parts of a trust be fixed and other parts discretionary?
Oh, absolutely. Very common, actually. You could easily have a trust where, say, the trustees have discretion over how to distribute the income each year among the children.
Right.
But the trustee says the capital itself must be divided equally between them when the youngest child turns 21.
So discretionary income, fixed capital. Got it. That seems quite useful.
It offers a lot of flexibility. Now, related to this, study task 1 in the materials asks you to explain this difference, fixed versus discretionary, using your own practical examples.
Mm,
It's a really good exercise to check your understanding.
definitely worth doing. Okay, let's move on. Bare trusts. Sounds simple.
It is. It's the simplest form, really. Minimal terms. The trustees hold the legal title, but they hold it entirely to the order of the beneficiaries.
Meaning the beneficiaries call the shots?
Essentially, yes. The beneficiaries can tell the trustees exactly what to do with the property. The trustees don't have any independent discretion or active duties beyond just holding the property and acting on instructions. They're often called nominees.
So the trustee is just a placeholder for the legal title, but the real owner, the beneficial owner, is pulling the strings.
You've got it. A common example is a stockbroker holding shares for you. They hold the legal title, which lets them buy and sell on your instruction, manage dividends, etc.
But the shares are beneficially mine. They do what I tell them.
Exactly. They're holding those shares on a bare trust for you. Simple, straightforward.
Okay. So that covers express trusts deliberately created. What about trusts that aren't set up intentionally? Trusts arising by operation of law.
Right, this is a different category altogether. These trusts are imposed by the law itself, whether or not the person holding the property intended to create a trust.
The law just says this is a trust situation.
Pretty much. We can break these down into statutory trusts, constructive trusts, and resulting trusts.
Okay. Statutory trusts first.
Well, statutory trusts are, as the name implies, created by an act of Parliament, like the trust of land imposed on co-owners under Sections 34 and 36 of the Law of Property Act 1925. They're important, but specific to certain statutes, so they aren't our main focus for today's general overview.
Understood. So let's focus on constructive trusts. The law constructs them.
Exactly. They arise without any declaration of trust. The courts impose them in certain situations where it would be unconscionable, basically, really unfair for the legal owner to keep the property entirely for themselves.
Okay, like preventing someone from unfairly profiting.
That's a major area. A key example you absolutely need to remember is breach of fiduciary duty.
Yeah.
Think FHR European Ventures LLP v. Cedar Capital Partners LLC. Remember that name. FHR European Ventures.
FHR European Ventures. Got it. What did it establish?
The Supreme Court held that if an agent, someone in a position of trust, like a company director or a trustee, takes a secret commission or bribe in breach of their duty, they automatically hold that secret profit on constructive trust for their principal, the person they owe the duty to.
So the dodgy profit belongs legally to the person who is wronged.
Yes, the constructive trust arises instantly. This was also confirmed in Crown Prosecution Service via Aquila Advisory Service Ltd. So, repeat, FHR European Ventures, breach of fiduciary duty, constructive trust over the secret profit.
Okay, FHR and Aquila. What other situations trigger constructive trusts?
Another big one is unjust enrichment, often through mistaken payments. The classic case here is Chase Manhattan v. Israel British Bank.
Chase Manhattan. Mistake.
Yes. One bank paid another bank money by mistake.
Oh.
A big sum, actually. The court said the receiving bank held the mistaken payment on constructive trust for the paying bank. So, core concept. Mistaken payment can lead to a constructive trust. Remember Chase Manhattan.
Right. Chase Manhattan, mistaken payment. Makes sense. Any others?
Well, there's the contract for the sale of land. Once you sign a binding contract to sell your house, but before the legal transfer is complete, the seller holds the legal title on constructive trust for the buyer.
Ah, so the buyer gets some protection even before they officially own it.
Exactly. Then there's the idea of perfecting imperfect gifts. This is where equity might step in if someone tries to make a gift but doesn't quite complete all the legal formalities.
Like they meant to give it, did everything they could, but maybe one form wasn't signed?
Something like that. Key cases. Rerose and Pennington v. Wayne. Repeat those. Rerose, Pennington v. Wayne. If the donor has done everything in their power to transfer property, equity might say, okay, it's effectively held on constructive trust for the intended recipient now.
Rerose, Pennington v. Wayne. Equity helping out. Interesting.
It is. There's also talk about strangers who knowingly receive or deal with trust property in breach of trust, potentially becoming constructive trustees, though that's a complex area.
Okay.
And, very importantly, constructive trusts are crucial in disputes over the family home, especially for unmarried couples. Think Stack v. Dowden and Jones v. Kernot. Repeat. Stack v. Dowden, Jones v. Kernot.
Stack v. Dowden, Jones v. Kernot, family home cases.
Yes, the Supreme Court used constructive trust to find that the ownership shares reflected the parties' actual common intentions and contributions, even if the legal title didn't show that. It reflects the reality of their shared lives. So, Stack v. Dowden, Jones v. Kernot, common intention constructive trust for family homes.
So constructive trusts are a really flexible tool for achieving fairness. Now, you mentioned institutional versus remedial constructive trusts. What's that about?
All right, this is a bit more theoretical, but important. An institutional constructive trust is one that arises automatically by operation of law as soon as certain facts occur. Like the FHR situation, the trust arises the moment the bribe is received. The court just declares it existed.
So it's based on established rules.
Exactly. A remedial constructive trust, on the other hand, is seen more as a remedy that a court chooses to impose at the time of judgment if it thinks it's the fairest outcome, even if the situation doesn't fit a neat pre-existing rule.
So it's more discretionary for the judge.
Yes, and that's why English law has been quite hesitant about fully embracing it. There's a concern it gives judges too much uncertainty and power. The case Angove's Colady Ltd v. Bailey touches on this skepticism. The key difference: institutional arises when the facts happen. Remedial depends on the court order.
So English law prefers the certainty of the institutional type, mostly. Still debated, though.
Oh, definitely. Lots of academic debate around remedial constructive trusts.
Okay. Let's move to the next type, arising by operation of law, resulting trusts. You said the name means to jump back?
Yes, from the Latin resalire. The idea is that the beneficial interest in property jumps back, or results back, to the person who originally provided it in certain circumstances.
Why would it do that?
Well, again, there's some academic debate on the exact classification. Are they implied express trusts? Are they constructive? Or their own thing? But a very helpful way to understand them comes from McGurry J. in Re Vandervelde, number 2. Remember Re Vandervelde?
That's Vandervelde, number 2. Okay.
Yeah.
What did McGurry J say?
He identified two main types: presumed resulting trusts and automatic resulting trusts.
Presumed and automatic. Let's take presumed first. When are they presumed?
Typically in two situations. First, if I transfer property, say shares, to you for free, a gratuitous transfer, and there's no evidence I meant it as a gift.
Uh-huh.
The law presumes I didn't intend to give away the beneficial interest, so it's presumed you hold the shares on resulting trust for me. The benefit jumps back.
So unless I can prove it was a gift, it's assumed I still own it beneficially.
That's the starting presumption, yes. The second situation is if I pay for property, say a house, but the legal title is put in your name. Again, if there's no evidence I intended a gift or loan.
It's presumed you hold it on resulting trust for me, the one who paid.
Exactly. The beneficial interest is presumed to result back to the person who provided the purchase money. So the core concept for presumed resulting trusts: apparent gifts or contributions where intention isn't clear, the benefit is presumed to return.
Okay, presumed. Unclear gifts. What about automatic resulting trusts?
Automatic resulting trusts happen when someone sets up an express trust, but that trust fails for some reason, either completely or partially.
Like the purpose becomes impossible, or they don't specify who gets the property in the end.
Precisely. For example, I transfer property on trust from my daughter for her life, but I don't say what happens after she dies. The life interest is valid, but there's a gap afterwards.
So the property is sort of left hanging.
Yes, the beneficial interest hasn't been fully disposed of by the trust terms. In that situation, the remaining beneficial interest automatically results back to me or my estate if I've died. It's not based on my presumed intention. It just happens because the trust didn't cover everything.
So automatic resulting trusts, failed trusts, or gaps in trusts. The benefit automatically bounces back.
That's a good way to put it. Apparent gifts and failed trusts are useful shorthand descriptions for the two types identified in Re Vandervelde, number 2. Though, as mentioned, the precise theory behind them is still debated. We touch on that more in Topic 12 materials.
Good to know. Now, what about implied trusts? We see that term sometimes. Where does it fit?
Implied trusts. Honestly, it's best to avoid using this term nowadays because it's just too ambiguous.
Ambiguous how?
Well, implied could mean implied by law, in which case we're really talking about constructive trusts, which are imposed by law. Or it could mean implied, in fact, meaning you can infer from the person's actions and the circumstances that they intended to create a trust, even if they didn't use the word trust.
But if it's based on inferred intention,
Then it's really just an express trust, isn't it?
hmm.
An express trust doesn't have to be explicitly written down using the word trust if the intention is clear from the context.
So implied trust either means constructive trust or express trust. Doesn't add anything new.
Exactly. It's a redundant category that just causes confusion.
Hmm.
So, standard advice. Analyze the situation. Is it imposed by law, constructive, or based on inferred intention? Don't get bogged down by the label implied.
Clear advice. Avoid implied trusts. Okay, let's shift gears slightly. Testamentary and inter vivos trusts. This sounds like it's about when they happen.
Precisely. It's about timing. A testamentary trust is one created in a person's will.
So it only kicks in after they die.
Correct. It takes
Got it.
effect upon the testator's death. The executors of the will are often the first trustees.
And inter vivos.
Inter vivos means among the living. So an inter vivos trust is one set up by the settlor during their lifetime, and it takes effect straight away, or whenever they specify during their life.
So will trusts versus lifetime trusts.
Basically, yes. And both are very common ways of creating express trusts. Study Task 3, by the way, asks you to define these terms, so make sure you're comfortable with that distinction.
Testamentary versus inter vivos. Got it. Now, purpose trusts. These sound different again, not for people.
That's the defining feature. Purpose trusts aim to achieve a specific purpose or goal, rather than benefit identifiable human beneficiaries.
Like setting up a trust to campaign for a new alphabet.
That's the famous or infamous example from Rishaw, yes, where the trust to research a 40-letter alphabet failed. The general rule is that non-charitable purpose trusts, often called private purpose trusts, are void
Why void?
because of the beneficiary principle. A trust needs beneficiaries who can go to court and enforce the trust against the trustees if things go wrong. If there's just a purpose, who enforces it?
Right, no one has the legal standing or incentive to make sure the trustees do their job.
Exactly. So a trust for the purpose of building a really nice sandcastle would fail. There are a tiny number of exceptions, usually testamentary ones, like trusts for maintaining specific animals or graves. We'll look at those anomalies in Topic 5.
So generally, private purpose trusts are a no-go. But what about charitable ones?
Charitable purpose trusts are the big exception. They are valid. These are trusts for purposes the law recognizes as charitable, like relieving poverty, advancing education, advancing religion, or other purposes beneficial to the community under the Charities Act 2011.
And who enforces those if there are no specific beneficiaries getting the money?
They are enforced by the Charity Commission and ultimately the Attorney General, who act on behalf of the public to ensure the charitable funds are used correctly. See Sections 13 to 15 of the Charities Act 2011 for that.
So public benefit means public enforcement is possible?
That's the idea. Study Task 4 gives you some scenarios and asks you to classify them, including whether they might be valid purpose trusts, so that's another good check.
Okay. This seems like a good point to think about exams. There's a sample question mentioned focusing on McPhail v. Dalton.
Yes, a really crucial case for discretionary trusts. The question often revolves around Lord Wilberforce's point about administrative unworkability.
That's where the class of beneficiaries is just too huge. His example was all the residents of Greater London.
Exactly. Even if conceptually you know what a resident of Greater London means, the group is so hopelessly wide that the trustees can't realistically carry out their duty to survey the class and distribute the funds.
So how would you tackle a question like that?
Well, you absolutely must discuss McPhail v. Dalton itself and contrast its is or is not test for certainty of beneficiaries in discretionary trusts with the much stricter complete list test required for fixed trusts from IRC v. Broadway Cottages. Remember those two. McPhail for discretionary, Broadway Cottages for fixed.
Contrast the tests. Got it.
Then you need to delve into the aftermath of McPhail specifically, the case of Rabauden's deed trusts, No. 2. You have to discuss the different approaches taken by the 3 judges in the Court of Appeal on how to apply the is or is not test in practice. They didn't quite agree.
Okay, so Rabauden, Nor 2, and the different judicial views are key.
Definitely. Also mention other relevant cases like Rakel-Bankian on powers, maybe Morris v. Bishop of Durham for the beneficiary principle, and the West Yorkshire case, which is another example of administrative unworkability. And consider Retux, which suggested maybe trustees could use an expert to resolve uncertainty sometimes.
Wow, quite a few cases to juggle there.
Equity questions often require bringing together several lines of authority. And remember, always argue both sides. Acknowledge the difficulties. Is the McPhail test clear enough? Does the administrative unworkability concept make sense? Also, distinguish it from capriciousness, where the purpose itself is irrational, even if the class is certain.
So unworkability is about practical impossibility. Capriciousness is about irrationality.
Precisely. And the absolute worst thing you can do is just list the facts of the cases without explaining why they are relevant to the specific question about administrative unworkability, or just rewriting the question in your introduction.
Always link back. Does my paragraph answer the question asked?
That's the golden rule.
Okay, that's incredibly helpful exam guidance. The topic materials also mention other learning activities.
Yes, there's a crossword puzzle, a drag-and-drop exercise, multiple choice questions. They are genuinely useful for drilling the terminology. Don't skip them.
Active recall helps things stick.
It really does. And discussion activity 1 is vital, explaining the difference between a fixed trust, a discretionary trust, and an outright gift. Nailing that distinction is fundamental. There's also Quick Quiz 1 for another self-check.
So plenty of ways to test yourself, which brings us to the final check. Am I ready to move on?
Right. This is for you, the listener, to really gauge your understanding. Ask yourself honestly, can you now explain in your own words what each of these trust types means?
Express, fixed, discretionary, bare, simple, special, arising by operation of law, so statutory, constructive, resulting.
Testamentary inter vivos, purpose trusts, both private and charitable.
Hmm.
Can you define all those without looking back?
And can you spot where the terms might overlap or have slightly different meanings depending on context, like implied?
Yes. And crucially, can you outline the basic structure of these different trusts? Explain why they are classified the way they are. What are the key distinguishing features?
If you can do that confidently, you're in good shape for moving forward and for tackling exam questions on these basics. Be sure you can define and distinguish all of them clearly.
It's the foundation for everything else in equity and trusts.
Absolutely. Well, that wraps up our deep dive into the classifications of trusts.
Remember, getting these fundamentals right is crucial. Don't be afraid to come back to this, revisit the University of London materials, and practice those definitions and distinctions.
And maybe leave you with the final thought to mull over. Trusts law has developed historically, sometimes piece by piece. How does this potentially unsystematic terminology we've discussed actually affect how we apply these rules today? Does it help or hinder the goals of achieving fairness and upholding the settler's intentions? Something to think about as you continue your studies.